Well, good afternoon and welcome. My name is Joe Swimmer. I'm the Executive Director of Episcopal Parish Network, and on behalf of EPN and Episcopal Communicators, our partners, for this digital workshop, we are so pleased to have you with us today. It is wonderful to have this assembled panel to talk about copyright and churches and what you might need to know. And there will be some caveats that come with that from our speakers in just a few minutes. But we wanted to say thank you for joining us. Thank them for joining us. If you are not a member of Episcopal Parish Network, or you are a professional communicator in the Episcopal Church and you're not a member of Episcopal Communicators, we invite you to learn more about each of the organizations. There's some information that's been posted in the chat. Please do enter your questions or your comments for the panel in the chat. And we would also ask that if you can take a minute and put in where you're writing from and what your name is, that would be great, just so our panel can get to know you. With that, I'm going to hand it off to Christine, and thank you all so much for joining us today and sharing about copyright. Christine?
Good afternoon, everyone. Thank you so much for joining us today. My name is Christine McTaggart. I'm the Communications Director for the Diocese of North Carolina, and I'm the chair of the Episcopal Communicators Professional Development Committee. We are so grateful to the Episcopal Parish Network for partnering with Episcopal Communicators on this webinar, and we are so delighted all of you were able to join us, and we thank you for taking time this afternoon to join us. Here to answer the question of, can we use that? Copyrights and permissions for church communicators. We are delighted to welcome this afternoon Suzanne Bailey, Brant Mills, and David Scott. I'm going to introduce them to you and keep it short because they have great information to share with us today, and we want them to have every minute we can possibly give them. So Suzanne Bailey is a Deputy General Counsel for the Episcopal Church. A former litigator, Suzanne has worked for the church off and on for almost 9 years as a generalist and corporate attorney in New York City. Welcome, Suzanne. Brant Mills is the Minister for Communications at Christ Church Cathedral in Houston, Texas. Brant has been working in communications professionally since 2003 and worked in print, broadcast, and online media before joining the communications office of the Bishop of the Texas Annual Conference of the United Methodist Church. It's quite a handful there, Brant. For 14 years, he helped to resource 2,000 clergy in 680 churches before coming to the cathedral. Welcome, Brant. And David Scott is president and founder of Selah Publishing Company, an ecumenical publisher of church music founded in 1988. He has also been the organist and choir master at Trinity Episcopal Cathedral in Pittsburgh, Pennsylvania since 2003, and was formerly minister of music at St. James Episcopal Church in Hyde Park, New York. Welcome, David, and thank you to all for joining us this afternoon. I think I'm going to start and turn this over to Suzanne, and I will be keeping an eye on the chat. So again, please feel free to share your comments and questions, and we will answer them a little bit later on in our time together. Suzanne?
Hello, good afternoon. My name is Suzanne Bailey, and I'm Deputy General Counsel for the Episcopal Church in New York City. This presentation that I'm about to give is intended to give you an overview of some of the copyright questions that churches face today. It is not legal advice, and no attorney-client relationship is created by virtue of this presentation. If you have a legal question about your church's particular circumstances, my best advice is for you to contact the chancellor for your diocese. So let's begin. What is a copyright? The next slide, please. A copyright is a bundle of rights to a creative work. There are a number of examples of what a creative work is. It can be a book, song, video, painting, photo, speech, poem, sermon. And the example of rights to that creative work or the right of reproduction, distribution, the right to publicly perform the creative work, publicly display it, and the right to create a derivative work, which is a work based on an original creative work. A copyrighted work can be published or unpublished. A copyrighted work is a property right that should not be used without permission. Compensation for use of this copyright, compensation for use of this property right is a justice issue for the owners of each work. Now, what sort of protections are there for a copyrighted work? Creative works are protected for 95 years if published before 1978, or the life of the creator of the work plus 70 years if published after 1977. Copyrighted works do not have to be registered with the US Copyright Office, but if they are registered, there are additional benefits. And for example, the registrant can be eligible for statutory damages and can also file copyright infringement suits. Users must seek permission from the copyright owner. It's important for everyone to remember that owning a copy of a copyrighted work does not give you the right to copy it or distribute it in any way. Using a copyrighted work without permission is illegal under the US Copyright Act, a federal law, and can come with severe financial penalties. Unfortunately, there is no exemption from copyright law for churches. Fair use in general does not apply to churches, but it will be discussed separately later on in this program by Brant Mills, exactly what it means. Now, what if a creative work is in the public domain? Works that are not copyrighted or for which the copyright has expired are in the public domain and do not need a license or permission. Music published before 1927 is generally in the public domain. And so if a work is in the public domain, then you do not need to get permission. Now, these are some sources that you can look at later for finding creative works that are in the public domain. Now, a lot of people want to know, what is the worship services exception? Well, this exception allows churches to sing hymns or play pre-recorded music during worship without a performance license. This applies only to performing music. It does not apply to recording of a worship service, either audio or video, broadcasting or live streaming to Zoom, YouTube, Facebook, or other platforms. You must get a license for those things. What about performing music at a church outside of a worship service? For instance, at a concert held at a church. Well, if the music is copyrighted and there is no license, that is copyright infringement. By the way, I just saw in the chat that a question about getting a copy of the presentation in the PowerPoint slides. It will be available for download after today's program. So what about reprints of song lyrics and music for hymns? If the hymn is a copyrighted work, you must get a license. This applies to photocopies for bulletin inserts and choir rehearsals, and to projecting lyrics onto a screen during worship. Citing a source or attribution is not a substitute for a license. Even if a parish does not photocopy the music itself, it could be charged with copyright infringement if it is in possession of illegal copies made by someone else. Does a church need a license to play YouTube videos during worship services? YouTube service terms of service only allow for the playing of videos for personal use, not for public use and not for church use. Licenses are required for all aspects of the video itself, all music in the video, etc. to show it during an in-person worship or if the service is being live streamed or recorded. Unfortunately, there are no blanket licensing services for YouTube. This means that you have to go to the original creator of each work for a permission. What if a church creates instant DVDs of worship? Permission is needed for each copyrighted work included: songs, readings, film clips. It does not matter whether you are selling the DVDs or giving them away, you need to get permission. What about live streaming a service over Zoom or another platform? Again, permission is needed for each copyrighted work included: songs, readings, film clips. Where do I get a license for reprints or podcasts and streaming? Licenses to use much of the music regularly included in Episcopal Church services, including many hymns and hymnal 82, are available from One License. One License has many types of licenses that you can purchase. They include reprint licenses, limited podcast streaming licenses, podcast streaming license bundles, and practice track licenses. Now, there are a couple important things to note about One License licenses. They cover only the music and content in its own catalog. A podcast streaming license includes pre-recorded content and content that is streamed live. The number of downloads or viewings permitted are limited to no more than 3 times the average weekly congregational attendance. Congregations must report usage through One License's reporting system. And when a license expires, all materials licensed under it must be removed. And so that means if you have a streaming license and you've created a video of it and then you've posted it on your website and then your streaming license expires, then you have to take down that video. Here are some other resources for music streaming licenses other than One License, and there are others that are out there. These are just examples. What about using photos or artwork from the internet on your church's website? Even if it is widely available on the internet, you generally need to get permission to use the photos or artwork. Services out there track the use of unlicensed images, and they will contact you about improper use and ask you to take down the images and oftentimes ask for money. It is copyright infringement unless the church owns the photos or artwork, or the church gets a license, for example, through a stock photo website, or the church uses a hyperlink to the photo, which I recommend. Really, you should try to avoid embedding. That's where people get into trouble. What about other liturgical material in a worship bulletin or other worship guide in print or online? Well, here are some resources, from church publishing, from Forward Movement. And then it's always important to remember the 1979 Book of Common Prayer is in the public domain and can be used or adapted at any time. Now, this is something that messes a number of people up. What about playing videos at Sunday school or youth activities? You need to review the copyright information on the video case or at the beginning of the video carefully. If a video says for in-home viewing or something similar, a license is needed for public showing of the video. It does not matter whether or not you are charging to see the movie. Licenses to show motion pictures are generally available from the Motion Picture Licensing Corporation, and here's a link. What about the consequences for copyright infringement? Well, you can receive a takedown notice, but compliance with such a notice does not mean that you will not be liable for damages. Statutory damages range between $750 to $30,000. You can also be liable for actual damages, and in certain types of cases, criminal prosecution. So in sum, I'd like to tell you some takeaways from today's presentation. When in doubt, ask for permission. Purchase blanket licenses for your church's music licensing needs. For poetry, speeches, or other literature, contact authors or publishers for permission. Do not post photos that you find on the internet on your church's website. And lastly, follow the terms of all licenses. You should read what they require you to do and then follow them. And then especially if the licenses expire and you're no longer covered by them, then you need to take down what you have put up. So with that, I'd like to thank you for being here today, and also to encourage you to reach out to your diocesan chancellors when you have specific questions that arise in your parishes, and they can either help you or put you in touch with people who can. And with that, I would like to transfer things over to Brant Mills.
Good afternoon, everyone. So I wanted to share a couple of stories from my past experiences when I was a younger communicator working in the communications office for the bishop for the Methodist Church. One of them involves promoting an event for one of our churches. A pastor had sent me a PDF file that had some embedded images in it and asked us to promote the event. It was just a simple, normal little thing, but it had a montage of some photos in it. And I posted it on our website, and it sat on the server, and we posted the event for a few days and had a good turnout, and didn't think about it again. 3 years later, I received a DMCA notice from it sitting on our server saying, we own the rights to this image and you owe us $600. We would ask you to take it down. And we, otherwise, if you'd like to dispute it, it's going to cost you a lot more money. So we did some research. I did a reverse image search, found out that a little tiny, maybe 200 by 200 pixel image as part of this montage that was probably 800 pixels wide total, just as a little part of this PDF, was actually a Corbis owned image. So we reached out to our chancellor and they decided to do the research. The image ended up being owned by Corbis. They were going to charge us a lot more money if we did not comply. So the chancellor billed us 2 hours at $1,500 an hour and told us to pay the $600. So that gives you a little bit of context on what can happen and how much it can cost just for one infringement. I spent the next 3 days going through our server, making sure that we pulled all the images that were hosted on it that we might not have the rights to. And I only found 3 more, if that helps, because I was pretty diligent about it, but that's how that can work. Used to, they would send a takedown request and you would just pull it down. But now all the algorithms can just find images randomly across your server, and then they'll notify people and they'll just start sending out requests and tell you how much to pay, and they make it really easy on their end. The other story, early on in my career, I think this is probably around maybe 2010. One of our senior pastors came to us and wanted to host this event with about 600 people, and they wanted to use the title of a Beatles song to name the event, and they wanted to play the Beatles song throughout the event, and they wanted to live stream certain parts of that. I stopped. I was like, I'm not sure we can do that, but I'll look into it and see where we can go with that. And long story short, I ended up on the phone with one of Michael Jackson's lawyers because he owned the Beatles catalog at the time. They spent some time talking to me about what we wanted, so they understood. And he said, basically, I can get Michael Jackson in the room. I can draw up the paperwork. Here's what it's going to cost. It's going to cost me $5,000 to draw up the paperwork. It's going to cost me another $5,000 to fly Michael Jackson in, get him in the room so we can have the conversation. And then if he were to approve it, it would cost you about $25,000 more to pay for this type of licensing. And then you would be given a contract on exactly how and when you can use it. So if you'd like to move forward, we can do this. Otherwise, you know, I can tell you right now, he's going to say no, and you're going to waste all this money trying to do all of this, and then it's not going to do anything for you. He then spent about 35 minutes educating a young communicator on the ins and outs of copyright law, different types of licensing, site licensing, needle drop, mechanical, and different pieces, and showing me and talking through what those things can cost and how some of that stuff can work. So I just wanted to share those because it gives you kind of some context on what just a basic infringement might cost, or what it might cost to go and find something that's really common in public in that space. In terms of fair use, she had mentioned I would cover that a little bit. So U.S. Code Title 17, Chapter 1, Section 107 talks about limitations on exclusive rights for fair use. Basically, fair use doesn't really apply to the church. If you go on YouTube, a lot of the time you'll see people say no copyright infringement intended, but then they play the song or they post the clips of a video anyway, and that's not fair use. You can't just say, I don't intend to infringe copyright and then infringe copyright. You're still going to be liable. You're still going to have, you know, you can't use other people's stuff without permission, and you're always going to have to get a license. I would add that the provisions of the license are important because they're all different. There are pieces like copyleft, there are Creative Commons and other ways around that to where you can get a different type of license where it doesn't cost you anything, but you still have to follow whether or not those licenses tell you how you can use it, whether there's attribution involved or and every single place that you get a license from, or that you get a work from, even if it's royalty-free music or royalty-free uses of images, there's still provisions on how you can use them most of the time, and you have to be careful about that. And those licenses can change over time. So something that might be in Creative Commons for a while, that artist, the owner of that, might take it out and then they might put it back into some other place they can enforce their copyright. So if you don't have documentation on when and how you used it under that license, it can still come back to bite you later if you can't prove it. But back to fair use, there are a few things that actually do apply regarding fair use. So it only applies under criticism, commentary, news reporting, and teaching, scholarship and research. And only the court can really determine whether it's fair use, ultimately. So just because you believe it might be fair use doesn't necessarily mean it actually is. So you have to be really careful about that. You can't just assume that it falls under those provisions. When you get into actually having to fight for that, you have to, there's a 4-factor test, and they'll look at the purpose and character of the use, including whether it's commercial in nature, what the nature of the copyrighted work actually is, the amount and sustainability of the portion used in relation to the whole work, and the effect of the use on the market or the value of the copyrighted work. So if they are losing money on your use of it, or if you chose not to license something that they can license, it makes it more difficult to fight or to prove that you're actually using under fair use. So that's just the basic general overview, things like that. So beyond that, I just wanted to touch on music licensing real briefly. You can get all these licenses, but each of them have different provisions. Not every song is covered under every license, especially if like for streaming or on site licensing. So you have to make sure that that song that you want to use, that version of that song, because The music and the lyrics are two separate copyrights from two separate holders sometimes. So you have to make sure that the version you're using falls under the license you have. And you also have to report on that. Some people were surprised because they didn't realize they had to keep track and report on everything they're streaming and report on every song that they're using. And the licenses and the ways that they do that change. So you have to look at the specific license, but they have ways that either you have to report everything you use, sometimes depending on the size of your church, your audience. And then you also have to report sometimes quarterly or sometimes every few months or so. They'll just reach out and say, hey, during this period of time, what did you actually use? And then you have to report certain things specifically to that license, what they want in terms of the actual music that you used in that space. So there's a lot of levels and layers to some of this stuff. So it needs a little bit more in-depth understanding. A lot of times music people in churches will take that on because they understand it better than others. So just pay attention to the licenses, make sure whichever one you're choosing, you can ask the people who put those together. If you're going through CCLI or One License or whatever, they have really good folks who can answer some of those questions and tell you exactly what they need and how they need it. So just make sure you're doing your due diligence and make sure you're doing what you're supposed to. And I would like to hand off to David now, and he'll cover some information about publishing.
Thank you, Brent. It's good that you all are attending this session, because I know that we get a lot of questions about this and have, especially since the beginning of the pandemic. It's good to see all the parishes that who put their names up there. I know a number of you are our customers, or at least your churches are. I see a couple of church musicians on here who also are clearly the communications people for their parish. And I know it's not easy work doing this with copyright. There's just today in the Association of Anglican Missions, we have musicians, we have a listserv, and there's one asked, I am tired of researching if hymns and anthems are covered by our copyrights for streaming, and then having to change things and reporting them and then listing copyright information in the leaflet. And it takes time doing that. And he's asking, are we going to be streaming forever? Because I'm going to be stuck doing this forever. I think that's the basis of his question on that. And before the pandemic, really, most all the churches had to worry about was reprinting of copyrighted music or lyrics in your bulletins. That's what you had CCLI or One License.net, or a little while ago licensing, which was then absorbed with One License.net. So you were doing that and then reporting it. Now, as a publisher, all of our copyrights are covered under CCLI and One License. So even if things you don't find in the database, if you find the publisher as a participating publisher, if it says clearly their copyright, it's 99.9% certain that it's going to be covered under there. It's just that not every single title is included in those databases, because we've spent hundreds of hours adding things in there to get all the information, and we still don't have all our catalogs available. Particularly with streaming, which is more recent, because there was no way to reprint a choral anthem legally. You had to buy it, but now that you can stream, you have to report the copyright, the streaming use of that. So one thing, I want to put this in the chat, that there are different types of licenses. You're familiar with the reprint license, which is what you need to put any copyrighted material in the bulletin, and there are places like CCLI or One License that give you the right to do that for music. Now, reprint license for poems or other things that are images that are covered under copyright, I do not know of any single company that gives you the opportunity to do that, and then they pass money on to the copyright owners. That really, in my experience, is limited to the publishers of music and hymn texts and that sort of thing. The mechanical license is when you want to make a recording and sell it or distribute it. You don't have to sell it to be required to make it. Just because you're giving it out free doesn't mean that that doesn't require a license. Synchronization is what we all learned about with the pandemic, right? That's your streaming of your worship services or other things. And that's a separate license under separate right under copyright law. And so one thing that One License and CCLI both did was prepare that, or give the opportunity for people to purchase an additional add-on or standalone streaming license so that things that they have are covered by that. Now there's another company, CCS, Christian Copyright Solutions, that was listed in Suzanne's presentation, and they're one that actually cover an awful lot more materials. In fact, almost all the things in the world for music in streaming, because they go through ASCAP, BMI, CSAC, and then all the performing rights organizations around the world. So they actually have the largest number of things. So I'm also at Trinity Cathedral as the organist choir master and handle that for the parish. And we have One License and CCS so that we can report things. And I don't have to worry so much about, well, is this composer covered? Because with those two licenses, almost all of our library is covered under use, and things that are included in the Hymnal 82 or the supplements as well. One thing that I won't spend a lot of time on, but it's important to know that things that are from musicals or from Jesus Christ Superstar or Godspell, staging those, there is no religious exception for that in copyright law. If you cannot act out a scene from Godspell during the service without requesting grand rights or public performance for that. So you just have to be careful about it. Now you'll say, well, they probably won't find us, but I would remind us that we are churches and should, as churches, then do the right thing. From our point of view as a publisher, it's the licensing revenues through the pandemic that actually kept us from going under, because people were reporting the usage of our things. And even though we ended up furloughing a number of staff and all that, we would have had to close our doors if we didn't have that income stream. And it's important not only for us, but half the monies we get go right on to the composers and authors. And that added for what they did as well. I'm going to post a link some in probably the fall of the 2020, the American Guild of Organists had myself and Brenna Cronin, who is the general manager of OneLicense.net, on a recorded Zoom, and that talks about the issues, especially regarding music and using that with your streaming. So you take a look at that. They give you some background on there. So not only do you have to get the license, but as has been mentioned, you have to report it, because if they don't know what you used, then we don't get the money. And that is part of the contract, saying that you're going to be on One License or CCLI, is that you will report it. It does take time. It gets easier and easier. We're always trying to find ways to make it easier to find what things are. We're trying to add on our website the OneLicense.net numbers so that you can just search by that sometimes. So it helps the people that are creating the music that is being used in your parishes, and the companies that provide that. And I think we all want that to continue. As we know, it's not really the liturgy is not a dead art, nor is the what we do in it. So it involves a lot of composers, authors, throughout the hymnal 82, the anthems and the organ literature, the piano literature, whatever the band's playing, those are things that need to be reported and done. I know for my part of doing bulletins at the Trinity Cathedral, there's a website I found that I'll put in there that lists, there are a number of museums that have opened their collection in high quality photographs of their artwork that are in public domain. Since it is an image, they could hold copyright, but there are a number that have, I think, rightfully said that they do not hold it. So if you take a look at that link I sent, it has a number of museums, in the Met Museum in New York City, the Chicago Institute, the Getty. They have major collections, Cleveland Museum, and they list what you can use in there. And really, if it's before 1927, as Suzanne said, it's in the public domain. And that next year it'll be anything from 1928. And then the following year it'll be anything from 1929 is fair use. It's a rolling thing up until we get up to 77. But remember that if something was public domain, say for example the hymn tune "How Firm a Foundation," there can be copyrights of "How Firm a Foundation," both in a choral setting or an instrumental version, which then means that that is a new copyright. It is using some public domain material, but it is creative contribution to it that is covered under the copyright law and making it a copyrightable product in there. There's a question, two questions. Yes, the hymnal does have a list of hymns with copyrights for words and or music. The hymnal was published a while ago, though, and a number of those companies have been sold and or absorbed. So it does sometimes take research, but that also the bottom of the page, if there is copyright on later publications, it has to be listed on the actual page when reprinting, and you can find that information there, which makes it easier. One thing I've found when trying to find things in the databases such as One License or CCLI, you start more broadly. You don't say you use just a few words of it rather than the whole opening phrase, because either you might put an apostrophe in the wrong place or have one of the words wrong and it won't come up finding it. It might suggest things, but the starting search broader helps you find what's in there, because we end up having a lot of people that I'm sorry, I lost my train of thought while I was trying to read the chat at the same time as talking. I am not a multitasker, clearly. And maybe I'll come back to remember what I was saying. There are a lot of in Right Song, and if a number of you use that, there are a number of things that are not cannot be reproduced without having One License or CCLI for the permissions. There are companies that don't participate in that. Descants, yeah, those don't usually, often those ours are from publishers that don't participate. So you do want to be make sure that you're paying attention with Right Song. If there are things not in there, that you are then reporting it through One License or CCLI. I'll stop talking then. I think I covered most of the things I wanted to talk. I'll be happy to answer any questions as well.
Well, that is good to hear, David, because we have a lot of questions for the three of you. Everybody's got a few things that they want to know about. But first, I want to thank the three of you. This has been wonderful so far. And we do have a lot of questions on a variety of subjects. In a couple of instances, I may try and combine them. And we've also got helpful attendees chatting some of the answers. So let's start with the first one I saw come in. That's asking about going back to songs being played during worship. What about the use of Spotify to play songs during worship? Does using a service like Spotify modify copyright responsibilities?
No, I think you still need to get permission for each of the songs. It goes back to who owns the copyright for the song.
And streaming pre-recorded songs is going to be a completely different issue than streaming on-site performed songs. It's going to be much more challenging to get those licenses, I believe. I generally don't allow anybody to play pre-recorded music because we don't have the licenses for that. And if an event's going to be streamed, we take that into consideration because we don't want to get on the wrong side of that. It can be very expensive.
Suzanne, I believe this is a follow-up to your mention in your presentation about the Book of Common Prayer being public domain. What about the new Spanish and French Book of Common Prayer translations? Right now, church publishing holds the copyright on them, and people do have to get permission and or pay to use them.
Then I think you need to contact church publishing about that. If they own the rights to it, then they're the ones that you need to contact. I just know for the English version that it is in the public domain.
And just to our attendees, we have a lot of questions coming in about specific softwares, sites, services. I'm going to hold those to the end to make sure we can cover some of our more general questions that cover a lot of ground. And then if we are able to, we'll come back and ask about specific sites and services. What are the policies around sharing news coverage and photos about congregations and or church leaders? And I think related to that, there's a question about, do you need permission? Is permission required of every person in a photo that's taken during a church service or a youth activity that you want to post on your church website or use in your communications channels?
Our general practice for taking photos or using visuals from a space, from a communal space, is we put a notice in our leaflets for our live stream services that participation in the service serves as consent, and that you're aware that we're broadcasting your image and likeness. In terms of events, for all of our hosted events, we have a disclaimer, and we have so our youth, our children, all their parents all fill out a form giving us the rights to share their images if they're okay with that. And we're aware of which ones choose not to sign, and they aren't taken. We never use a photo of any children or youth if we don't have permission from their parents to post it or to share it online anywhere. We make absolute certain that we don't share images of youth or children for a lot of different reasons without their permission. Generally, when we have huge events, we'll post notices on the exterior doors so that when they enter space, they're aware that we're taking photos. And we also say that we intend to post these publicly. So that helps with that.
Great. And this question was brought about by the live stream. Suzanne, you were mentioning about needing to have the license for every component in a live stream. But this really applies to all communication channels. What's the best way, or how do you indicate that you have permission for everything in a live stream? And especially when the broadcast is happening, is there a best practice for indicating that you're allowed to use everything so you don't get questioned?
I mean, you could put something at the beginning or something at the end of the live streaming to that effect, but I mean, it doesn't have any legal effect unless it's true. You know, just saying it doesn't make it true.
But you don't have to document it as you go. You could just do a part at the end with your.
Right.
Okay.
Right.
Great. Okay, we have a question about distribution.
Yeah.
Say this person wants to use a poem in a sermon. Can they print copies, distribute the poem during the sermon, collect the copies before the people leave the room? Does that count as distribution or inappropriate distribution?
That counts as distribution, unfortunately. And those are copies that you made that you weren't supposed to, you didn't have the right to make. So you definitely could get in trouble for that.
Okay. So here's one. We have a person who diligently searches for art and bulletin covers, does their best to avoid all copyright works. If they're not sure, they contact the artist and the website, occasionally pay a fee. But sometimes there's just no information on the copyright or contact information. If something is posted with no copyright and no website or contact information is provided, can it be used?
Copyright is automatic when you create a work. So if somebody creates something, and the test used to be whether it was put into a tangible medium, but I think that's changed a bit. But once a work is created, it's automatically copyrighted. It doesn't need to be registered. The creator of that work owns the copyright. So if you don't know, you don't automatically have permission to use it. I would assume that it's protected somewhere, and I'd go to the effort of figuring that out, or I just wouldn't use it. It's not worth the liability potential.
Right. Do you have suggestions on, or we've got another question about when you're searching online for free art, how can you tell if an item is copyrighted? Do you have any suggestions on how to begin that search?
Reverse image search, Google Lens are great tools to find things that to find the origination of something. A lot of times I've been sent stuff and people are like, here, just use this to promote our thing, or this is a great image for, referencing this event or whatever. I think we should use this. And I'll just do a reverse image search. Half the time I'll find out that it's a stock image from somewhere, so we can purchase the rights to it, but they didn't. Or I'll find out, and you can track back and find out where it came from. Sometimes some of these images are in like 5-10 different stock sites, so you can search through and figure out which one's the cheapest for your use. But most of the time you can find a version of it somewhere and then figure out where it came from. Not all the time. Sometimes it's challenging. I just say don't use it if you can't figure out where to get the rights. And on back to the poetry question, we've published some things where it was really simple. We wanted to use snippets of this or that. We just reach out to the publisher and ask. A lot of times for nonprofits, they're like, sure, use it. You can use it, you can print it. You can print it in this many copies of your publication, or you can keep it online for 2 months, which surprised me. They put a time limit on it, and they asked us to destroy all copies of print materials after 6 months, and to take it down and not have it online again after 2 months. So there's things like that to look out for as well.
We have a person who has gotten conflicting advice on whether it's okay to insert music in a bulletin if you own enough copies of the hymnal that everybody technically could have read it out of said hymnal. So for example, if they own 75 copies of hymnal 1982 and they have 70 people worshiping, and they put hymns from that hymnal in a bulletin without a separate license?
I can answer that. Buying the hymnals does not give you the right to reproduce copyrighted works. It gets you the right to use that hymnal. So by doing that, you still need to get permission for it. Now, when we have one-time things come through, a couple of exceptions, and Sela does this and a number of other publishers as well. If it's for a funeral or wedding, often the publisher will say there's no charge, because we understand those are either difficult or very special occasions. So we grant free permission in those instances. But if you do have the hymnals, that doesn't mean you can copy it. Now, if it's a public domain hymn, one from before 1927, you can copy that to your heart's content and put it in your bulletin. It's only things that are under copyright that require additional information. One of the things I was looking at some of the comments, there's one of the things Suzanne said that is not always clear to people, that the religious exemption applies to worship services only. It doesn't apply to if you're having a concert in your church, if someone is doing another event with live musicians. Those you need to get performance rights for. Now, and that's where a company like CCS, they cover that. One license doesn't cover anything beyond worship services. And it says so clearly in the license, if you're looking at that, you can have it, you can get separate licenses for special events and other things, but the streaming licenses for streaming worship services, not for streaming concerts or other things. Of course, one way to get around that is to make it a worship service, start with prayer and have a short litany of something. It doesn't say what percentage is a worship service. It's just saying whether it is a worship service or not. And there are other people talking about the problems they have with Facebook or YouTube flagging them or taking things down. And the easiest way to get around that, if you're doing everything legally, is to stream to your website. Streaming to your website means that you don't have those issues and have to spend hours every week going through asking them to say that that was not the New York Symphonic Orchestra playing, that was our children's orchestra. I'm always flattered when I get flagged for that. It's like, wow, I didn't think I played that well. But as these concert artists who have CDs of some of the things I've done. But that's another instance. But streaming to your website can solve a lot of those problems. And it's not as difficult as you might think to, if you're already streaming, to do that, to set up your website to stream.
We get hit every week on our Facebook. So we stream to both Facebook and to Vimeo. We use Vimeo to embed to our website. We get hit all the time through Facebook, and we get hit for our Spanish language service from a company from a group out of Chile who continually hits us every week. It doesn't matter. And a lot of the works that they do, because the musicians write their own music, are completely and wholly owned and performed in-house. And they still hit us for copyright for things that we know for a fact that we own. So we have to dispute that through Facebook, but Vimeo doesn't have the same problems that YouTube has with that. So we've been able to just post our licensing information and do exactly that. And it hasn't been an issue through that channel.
That was the big question. So you guys went right into it, and thank you. I know that was on the minds of a lot of people. Here's an interesting one. Somebody wants to know if someone is renting your space. I'm sorry, y'all. They're all interesting. I don't mean to imply that this one is extra interesting. This is just what I haven't heard before. If someone is renting your space and doesn't meet the legal requirements for copyright, is the owner of that space liable if they have it written in their policy that copyright and licensing requirements must be met? Where does liability fall?
Well, most likely it's going to fall on the people who infringe, but that won't prevent you from being sued. So you could put in your use agreement something about how they have to follow all copyright laws and will indemnify you for any action that arises out of their use of copyrighted material.
In a similar vein, Suzanne, don't mute yourself yet. If somebody is offering a performance at their church, they've done all their homework, they've got all their licensing, but somebody attending makes a recording on their phone and posts the recording, is the church liable?
I would think that probably in the end they will not be liable, but that will not prevent the church from getting sued and being embroiled in things. So that you could get sued, but if you have all the permissions for what you did, then you should be okay. And what the private individual did, they should be liable in the end for that.
In a similar vein, what happens if you retweet or reshare something on social media that someone else originally posted? And it turns out that their original social media post is in violation of copyright. Can you get in trouble for retweeting it, sharing it, etc.?
Yes. If you repost the image, even if someone else has done it, and it's copyright infringement, and you post it as well, then that can be copyright infringement as well.
If you're promoting an event and utilizing the content that the event organizer is putting out, does that require further permission?
I didn't fully understand the question. Did you ask it again? I'm sorry.
So somebody's doing an event. Let me find it. If a church is promoting an event and utilizing the content that the event organizer is putting out, do you need further permission to promote that event? In other words, let's say, okay, we all know that this wonderful festival is coming up from the Episcopal Church in July, and we're all talking about, it's all about love. The church has been putting out materials on this. A lot of folks are resharing that information. Is that okay, or do we need to get special permission from the Episcopal Church to use the event information they are putting out to promote their event? Basically, if you're helping somebody out, how much permission do you need to get from them?
So a lot of licenses aren't transferable. If we're talking about images and somebody purchases a license to use an image from a stock site and they put it on their marketing materials and they print it out and distribute it, that's, they're covered. But if they send it to you and you take that image from your email, you post it on your website, you as an entity, as an organization, a separate party, doesn't own the rights to that image because you didn't purchase it and you didn't pay for the rights to host it on your site. So you could be infringing in that case.
Would be a hard infringement if you're helping somebody out, but
it depends on the license.
Right. It's good to know. So we're coming up on the 4 o'clock hour. I will ask you this question. We had a lot of questions come in specific to sites, pixabay.com, using images in Constant Contact or MailChimp, for images on Unsplash. There were a lot of very specific softwares and services. We're not going to have time to talk about each one. Can you share, though, most of these sites, I believe, have licensing information on them. Can you share what kind of information a person might expect to find if they were to read the licensing information?
Everything is going to be license specific. Sometimes some of these sites, like I like to use Pexels. You have to be careful in the searches because they also advertise stock sites. So some of the sections on the site have royalty-free images. Some of them are completely free to use. And then they also link to iStock. So if you click on the wrong image and you go to grab that one, it's not free and you don't have the rights to it unless you purchase it. Some of these sites have creator specific licensing, so they can determine the level of rights for each image that they host there. So you have to look at it to see whether whether it's free. You have to look at that specific image and the specific license to determine whether or not you have to use attribution when you share that image. So you might have to list the creator and potentially a link back to the work that you downloaded. And you have to pay really, really close attention to that. You also need to document it because they have the right to change the level of documentation or the level of use that you're allowed when you download these free images. So Pexels, Unsplash, some of these places, they have a lot of really good materials for churches, but you have to pay really close attention and you have to keep up with that. They can change their copyright status on those things at different times. And they might host them through a different site. So you can find the same images in different spaces. Sometimes it's free over here, sometimes it's paid over here. And if they ask you later on through a DMCA request to take it down and you owe them money now, if you can prove that you downloaded it under Creative Commons, copyleft, or through one of these free sites that give you the license to use it, then you should be in the clear. But you have to be able to prove that. So you have to document when and where you got that.
We have one last question before we wrap up. This goes back to the fair use question and some of the where to find information. What about showing, if a church is showing a movie and having a discussion on it, or a documentary followed by a discussion? Is that considered educational? If not, where do you go to find out about the licensing you might need?
That can vary. I defer to the lawyer, Suzanne.
I guess I have to admit, I don't know the cold and hard answer on whether that would be fair use or not. In the educational context, it probably doesn't fall under that. I would advise you to get a license. In my presentation, I provided the link to the website for the Motion Picture Licensing Corporation. And if that doesn't have the particular movie, then you probably should be able to look on the web and find out for that specific movie where you need to seek permission.
There are a couple of places that do similar things where you can buy the license to run certain movies in specifically in a church setting, to view those. I don't remember the names of them. It's been a few years since I've looked at that, but those licenses do exist. Generally, I would say it's not going to fall under fair use if you're just watching a movie together.
Suzanne, can you repeat one more time the link to the Motion Picture Association?
So it's mplc.com.
And folks, everything that was included in Suzanne's presentation, you will have a copy. This was a wonderful segue. For everybody who registered for today's webinar, whether you were able to attend or not, you will receive a follow-up email in the coming days letting you know where you can find the recording, as well as any other information that will be shared out after. And that will include the links and the information that was shared today. But I believe we are out of time. And so once more, I want to thank Suzanne, David, and Brant for your wisdom, your time, your resource sharing, the information sharing. I think everybody has learned a lot, is going to be very conscientious and intentional about tracking down their copyright and their licensing. And I thank all of you who were able to join us today. Thank you for your time and for being a part of this with us. And we hope you will join us on future webinars. Look for more coming soon. Have a great afternoon, everyone.